Okay, we're going to start up our next panel. I'm Professor Jeanne. I teach here at the law school, and I am one of the faculty co-directors of the Engelberg Center. I teach and write on a variety of intellectual property matters, including patent law and patent litigation. So I'm really excited about this event for today. And I just wanted to take the time before we got started to briefly introduce our two speakers, a wonderful pair of legal historians. And I'll introduce them in the order that they're going to speak. First, Jim Oldham of Georgetown Law. He's the St. Thomas More Professor of Law and Legal History there. And he's written a number of major works on legal history and the role of juries in patent law and the role of juries more generally. His major work is the Mansfield manuscripts and the growth of English law in the 18th century, a 2-volume work, which has now been abridged as well into 1 volume. And I have to also mention his book, Trial by Jury, The Seventh Amendment and Anglo-American Special Juries, published by the NYU Press. Even though it's off topic, I must also mention that Professor Oldham specializes in labor law as well and is currently the neutral discipline arbitrator for the National Hockey League and the NHL Players Association. He's a salary arbitrator for Major League Baseball and the MLB Players Association, and appeals panel member for the NFL and the NFL PA, the Players Association as well. So a very interesting confluence of experiences and very excited to hear him speak shortly on juries in patent cases. And then I want to introduce our other panelist, Renee Lerner of George Washington Law. And she works in the fields of U.S. and English legal history and focuses on the history of U.S. procedure and legal institutions, especially juries. And she's written with John Langbine and Bruce Smith the book History of the Common Law, the Development of Anglo-American Legal Institutions. She's written a number of book chapters, articles on the role of juries, and she's currently working on jury selection as well. So we're going to have this is titled A Scholar's Debate. We'll see how much debate there is, because I understand that Professors Lerner and Oldham have a lot of agreement between them, although there are some pockets of disagreement as well that I hope we'll get to highlight. And we'll be addressing whether the Seventh Amendment guarantees a jury trial in patent litigation. They'll each take some time speaking, then we'll have a bit of a conversation and some time for questions and answers.
Thank you very much. Thank you for inviting us to be part of this conference. It's going to be an interesting thing for both of us. I need to correct one thing. You said that I was the neutral discipline arbitrator for the National Hockey League. Well, last month I was fired from that position because I had issued a decision that is now on appeal before the federal court in New York involving the Dennis Weidman case, and if you're a hockey fan, this will quickly ring a bell, but it was a case in which the player, according to the video that went viral, cross-checked a referee and flattened him onto the ice, and the player was disciplined for 20 games, suspended. I reduced the suspension to 10 games, and for that I was sent packing by the NHL. But I fully expect my decision to be reinstated or upheld in federal district court. We shall see. It is interesting, by the way, to have those two fields, legal history, 18th century English, which is my specialty, and modern arbitration. And as a result of that, I've done a lot of work on the history of arbitration and have published about that, both in England and in this country. And arbitration is a wonderful, venerable process. The first text on arbitration published in England was published in 1694. I have a copy in my office of The Complete Arbitrator, a text in 1731 that would speak to the modern practitioner completely understandably, because the system is essentially the same. But let's turn to patent issues. It's true, Renee and I have been on panels before, and we fundamentally agree on most aspects of this subject. But what I want to do is two things. One, talk about the Markman case, and then to talk a bit about the complexity exception, both of which were mentioned before. First, what I will tell you is the Markman case was incorrectly decided. And my first confession is I was a consultant to Markman in that case. And as we trod over to the court in a ferocious snowstorm, the Supreme Court was the only branch of the federal government that was operating that day. I said to Markman that I'm sure it will probably be a divided opinion. One thing you can be sure of is that Justice Souter will be on your side, seeking a jury. And of course, I was 100% wrong about that. Souter was not only not on his side, but he wrote the opinion for a unanimous Supreme Court saying that a jury was not required for the claim construction issue in that case. Now, after the case was over, I did something that I had never done before and have never done since. I wrote Justice Souter a letter, and I wrote to him saying, I'm writing in connection with your decision in Markman. I hope I do not offend propriety in doing so. I confessed my involvement with Markman as a consultant, but I said I obviously was not writing to quarrel with the outcome. I personally disagreed with it, but the court had decided it, and it was now the law. But I said there were a couple of things in his footnotes in the case that I thought he would appreciate some commentary on. And the first thing was he quoted an author, a 1984 book by Dutton, which I expect most of you know, on the history of the patent system in this country. And he quoted him by saying that at the turn of from the late 18th century, the state of knowledge of patent law in the courts in England was quite primitive. And he quoted him by saying there were no more than 22 patent cases that came before the Superior Courts of London in that time. And I explained to Justice Souter that this was not correct. The 22 figure referred to cases that were in the printed reports. But in the late 18th century in England, there was no official court reporting. It was an interesting and to us a strange process. But the only cases that were reported at all were the cases where the full four-judge court had assembled to hear motions, post-trial motions, a motion for a new trial or a motion for again, that the verdict was against the evidence or the like. What was not in the printed reports was any account of the jury trials. And there were thousands of jury trials by the three common law courts that were operating in parallel. As I was, my introduction to the English legal history process was by looking at the trial notes of the first Earl of Mansfield, Lord Mansfield, who was Chief Justice of the Court of King's Bench for 32 years in the late 18th century, from 1756 to 1788. And only about half of his trial notes survive. But within those trial notes, there are almost a dozen patent cases that are unreported. There's no printed record of these cases anywhere. And that's because they went to a jury trial, and the jury's verdict was the end of the dispute. There was not a formal appellate process then that was in place in the way that we know it. Trial court, jury trial reporting began in the 1790s, but it was quite sporadic and inconsistent. And even once it did begin, I looked at the trial notes of a successor Chief Justice of the Court of King's Bench, who was in office from the 1802 to 1818, and he conducted thousands of jury trials. And even then, when trial court jury trial reporting was in existence, only less than 10% on average of the jury trials that he conducted got into print in the jury trial reports. So there was a huge volume of activity in the courts in jury trials that simply was not known at the time. So that was point one. Point two in my letter to Justice Souter was, I was a little surprised when he said that he was disinclined to put much stock in what I had supplied to the court, the notes that were found of a sitting judge in the Lerner case, which you may know, which was a 1770 case dealing with the patent for a stucco product that was for exterior use in housing. Indeed, Lord Mansfield was the judge in that case, and he had purchased the stucco for his own country residence, which survives to this day. It's Kenwood. It's a wonderful little museum at the north end of Hampstead Heath in London. But the Lerner case, one of the junior judges of the Court of King's Bench was assiduously taking notes of what happened in this case. And the case was a detailed case about the chemical composition of the stucco that was being applied. And the question was what was given to the jury. And the focus in the case was on the specification. And the specification I was suggesting to the court was very closely related to the concept of the claim as evolved in our law. And Mansfield quite explicitly said that I gave all aspects of the specification to the jury. And Justice Souter, in his opinion in the Markman case, brushed that aside by saying it was ambiguous. Okay. So I sent this letter to Justice Souter, and I said I was surprised that you said you preferred to look at the printed reports and to credit the printed reports rather than the notes that might have been taken. So I sent this letter in May, and I heard nothing in May. I heard nothing in June, and I thought, oh, I have committed a huge faux pas here. But in July, I got a really lovely letter from Justice Souter responding to my letter. He apologized for taking time. He said about the nature of the jury trial and the non-reporting of jury trials. He said, you are, of course, right in saying that the brief quotation in Note 4 should be qualified to avoid the misleading character that you point out. And he said, but it's not too late. He said, the official print of the Markman case has not yet been produced. So he said, I intend to insert a reference to reported cases so that it reads only 22 reported cases appeared in England at the time. And these are the gratifying moments as academics when we influence the law. And sure enough, now in the printed report, the word reported is bracketed in after 22 cases. Of course, he didn't say anything about this ocean of jury trials that were being conducted that never got into the printed reports. And even, by the way, I'll just mention, court reporting at the so-called appellate stage, when the full court was considering motions, all four judges sitting together, some of the, not all of that, even that activity was recorded. The other major common law court in England at the time was the Court of Common Pleas, and it's interesting to note, just in passing, from 1780 to 1788, the number of printed reports in the regular, typical reporters that got published from the Court of Common Pleas is 0. There are no printed reports from those 8 years, even when the full court was sitting. And it's just because there was no official court reporting and there was nobody there doing it. So it's a very, so I'll tell you about the second point, and then I want to come to the Markman case and to Justice Story's creation of the historical test. Are you keeping time?
Got a few minutes.
Okay. On the second point, Souter said, I suppose my reaction about preferring to have the language in what he called the established reports. It was an interesting expression because there were no established reports. It was all entrepreneurial. If a lawyer or a barrister went and took notes, he could go find a printer and publish them, and that's how it happened at the time. But at any rate, he said, I suppose my reaction reflected our implicit faith in the accuracy of modern reporting, as well as the former state trial and appellate judges' knowledge of what some judges do with their notes in giving a jury charge. He said, I personally did not write out jury charges verbatim, but I made extremely careful notes and was meticulous in following them. I became keenly aware over the years that quite a number of my colleagues did not make either good notes or follow them carefully, hence my suspicions about judges' notes. But I had told him that the junior judge of the Court of King's Bench, whose notes I was quoting, had become a judge only the day before the Markman hearing, the Lerner hearing was conducted. So Justice Souter said, well, as far as Judge Buller and the Lerner cases are concerned, you have the trump card. If a judge is ever going to keep good notes, it's when he's a fresh judge. All right. Well, so what happened? In the Markman case, I don't need to rehearse it for you. You probably know half of that opinion by heart. But the first thing that happened was the court did not do what many of the court watchers thought was going to happen in this case, and that is that the moment was going to be seized to do something about the historical test and to say its day is done and let's face up to the fact that it doesn't make much sense to continue to judge modern cases against a metric that goes back to 1791. But the court didn't do that, and the premise for the Markman case by Justice Souter was we begin with this case. And what does the historical test mean? Well, that takes us to the Watson case in 1812 and Justice Story's decision. He said the language of the Seventh Amendment cannot have meant the law of any individual state because the law was different in the different states. So it must have referred to the law coming from that grand reservoir of our jurisprudence, the law of England, as it was known in 1791 when the Seventh Amendment was adopted. And he said, in fact, I think this is so obvious it must be clear to everyone that this is so. Well, Justice Story was an extremely smart man, and I wonder if he really understood the implications of what he had just said, because that locked in this test, and it governs us yet today. But the question that lies behind it is, how are judges going to know exactly what the law was in practice in England in 1791? And it is a difficult thing to figure out. And if you're not a documentary historian like me, who has plowed through reams and reams and reams of manuscripts, there's a good chance you'll get it wrong. I think Justice Souter got it wrong in this case. And I could say more about that, but let me just use 5 more minutes to talk about the complexity exception. And my views about this have sort of evolved over the years. When I first was involved with Seventh Amendment issues, I thought, my premise was nearly everything went to the jury in those days. It was just, the jury trial was the way cases were resolved. There was very, very, very small percentage of cases went forward on a joint demur where they were just asking a question of law. And of course, there was the law-equity divide, which is the other aspect of Markman, that you have to decide if it's a suit at law or if it's a suit that would go to the Court of Chancery where there were no juries. But nobody quarreled with that in Markman. He said this is clearly a suit at law. And so I was predisposed to say that the old argument that took place back in the day in the Third Circuit about whether there should be a complexity exception. I was on the side with Buzz Arnold, who said this would still stay with the juries. But I've changed my mind on that, and I now think that a complexity exception would be constitutional under the Seventh Amendment. Whether it's wise or not is a different question, as Judge O'Malley suggested. And the reason I do is that if you look closely at what happened from sources that are not typical reported cases, if you look at the London Times, which was founded in 1785, and every single day of the London Times is accessible electronically and word searchable, you can find lots of reports of cases that appear nowhere else. And if you look at other sources, you can discover that complex cases frequently befuddled the English judges. Lord Mansfield's successor was Lloyd Kenyon, who was Chief Justice of King's Bench, and he was very frank in his comments to his juries. And he would say, for example, in a maritime insurance case, he would say, I've been sitting here for the last 3 hours listening to words that I understood not one of. And why am I being asked to decide this case? And he said, but luckily, I have a special jury appointed, which was a jury of merchants, and thank goodness the merchants are going to tell me how to understand this case. And so that was one way that complex cases were handled, and it was extremely common. I've written a lot about the special jury. Secondly, another thing that happened quite frequently was the counsel and the judge would say, none of us really understands this case. We better send it to arbitration. And so counsel would come up, consult with clients, an agreement to arbitrate would be written out, and the case would be suspended and referred to an arbitrator who had some expertise, who, in one case I even found a special jury had been impaneled, and the special jury said, this is a case involving canal cutting and we don't know a thing about it, so let's send it to arbitration, which they did. And this was very common as well. They would send it to arbitration. So, and then thirdly, as has been pointed out in academic scholarship, there were some cases that started in chancery where it became clear that some fact-finding would be necessary, and chancery said, well, we don't have to send this over to the common law courts to get a jury to decide these questions of fact. We can do it ourselves, though we understand the preference is to do it. But the chancery did, in some complex cases, decide cases without juries. So if you package that together, recognizing as well that today the special jury is unconstitutional in criminal cases in this country and is impermissible in civil cases in federal courts because of the Jury Composition Act in the mid-20th century. And it's largely extinct in this country except in Delaware. Delaware preserves the special jury, and I can say more about that if anybody's interested when question time comes. But if you package that all together, I think it's permissible to say that what happened in the late 18th century with complex cases was almost always a result that did not involve a common jury. It may well have involved a special jury, but that's not available to us now. And so why in the world should we take that into account? So I think the complex cases could be removed from the Seventh Amendment protection if that step were to be taken. That's never been addressed by the Supreme Court. I'll stop there.
All right. Thanks to the Engelberg Center and the Civil Jury Project for holding this conference and inviting Jim and me to discuss this subject. And I say discuss rather than debate because, as you'll see, our positions are not that far apart. And I'm a little embarrassed about that. I feel almost as if we haven't earned our keep unless we gin up some serious disagreement here. But in any event, the conference, of course, combines two fields, jury trials and patent cases. And I am a jury person, not a patent person, but am delighted to be here. As a federal district judge once told me privately, trying a patent case to a jury is insane. That was the word he used. A federal circuit judge used a slightly different word when he wrote to me that it was, quote, crazy. This, of course, was in private. These judges would never dream of saying such a thing in public. Judge O'Malley suggested that we should stand apart from other countries, but their practices and their reactions can be instructive. It turns out those two judges are not alone in their opinion, and foreigners, and including those from common law countries, when told that we try certain patent cases to juries, are apt to first stare with incredulity and horror, and then to laugh. They say, those are the very worst cases to be decided by a lay jury. Why, they ask, would you possibly try a complex technical case to a group of inexpert lay persons? This is an excellent question. There are several possible answers, including some that focus on the interests of the American legal profession. But I'm going to set those aside for now and ask whether the U.S. Constitution, and specifically the Seventh Amendment, requires jury trial in patent cases. And I hope to do two things. First, to help explain, along with Jim, why the Seventh Amendment is so difficult to interpret, and to consider, given the Seventh Amendment, some possible alternatives to trial by an ordinary jury or an ordinary judge. So to tackle these questions, and particularly the first, it's helpful to know something of the background of the Seventh Amendment. We take the Seventh Amendment for granted today. It is there in the Bill of Rights. But the idea of a right to civil jury trial in federal court was a deeply contested issue among the American founders. So this disagreement was in contrast to the right to a criminal jury, which they all agreed on. Many thought a right to a jury trial in civil cases was extremely ill-advised. Alexander Hamilton, in the Federalist No. 83, explained why he thought such a right was a bad idea. Now, I'm a little bit disappointed in Mr. Miranda because it appears that he didn't compose any songs for his musical based on Federalist No. 83, but I think that would have been a great subject. But in any event, among the reasons Hamilton gave was that certain disputes are too complicated to be suited for civil jury trial. Another was that it would be virtually impossible to define the right. He proved to be correct on both counts. As you know, in the end, Hamilton's arguments did not prevent a federal constitutional right. James Madison reluctantly agreed to draft what became the Seventh Amendment. And he did so to avoid what he feared might be a second constitutional convention. In the Virginia Ratifying Convention in 1788, Madison had argued strongly against Patrick Henry about the need for a federal right to civil jury trial. Madison had slightly different reasons than Hamilton. Madison pointed out that the unpredictability of juries endangered contracts and thus commercial development. Madison's aim in drafting the Seventh Amendment was to placate anti-federalists such as Henry, while at the same time not giving up more than he had to. He immediately ran into the drafting problems that Hamilton had warned about. Jim has discussed the difference between law and equity, and the Seventh Amendment is based on that distinction. So in England, jury trials were limited to what were called the common law courts. And these were in contrast to the other courts in England, primarily equity or chancery, that used different procedures and sat without juries. The Court of Chancery dealt with many important matters, including mortgages, bankruptcy, fraud, trusts, and business associations. In America, some states had separate courts of equity, but some did not. The line between law and equity was different in each state. Therefore, the scope of jury trial was different in each state. Madison thus faced an enormous problem in drafting the federal right. Some urged him explicitly to specify the English common law as the one that should govern the scope of jury trial. Others urged him to follow the law of a particular state. Adopting any of these solutions would have caused great political problems. And so he did what politicians so often do. He was vague and kicked the can down the road. He wrote simply, in suits at common law, without specifying what common law. He didn't want to write to civil jury trial anyway. It was, of course, left to the courts to figure out what this might mean, and, as Jim has explained, Joseph Story said, well, it can't mean the law of any particular state because the states are all different. So it must mean the law of England, and as Jim quoted, the grand reservoir of our jurisprudence, of all our jurisprudence, he said. That was an interesting kind of Federalist view, although Story was not himself a Federalist. And so that is why we look to English practice to determine the scope of the Seventh Amendment to the U.S. Constitution. So at the time Story was writing in the early 19th century, the English common law had not changed all that much from what it had been when the Seventh Amendment was drafted. But it eventually became necessary to specify the era of English common law because, not surprisingly, the English law changed dramatically over the course of the 19th century and into the early 21st, or into the early 20th. And in fact, England now has essentially abolished the civil jury entirely. So it wasn't really until the 1930s that the U.S. Supreme Court specified that it must be the common law of England as of the ratification of the Seventh Amendment, although in certain cases the U.S. Supreme Court has certainly implied that. Well, a huge problem, of course, as Jim points out, was determining which practices were to be preserved under the Seventh Amendment. All courts and commentators agree that not every detail of English jury practice was to be preserved. The, I would say, intractable difficulty is deciding which practices could be jettisoned and which needed to be kept. And I think the field of patent litigation amply illustrates the difficulties of trying to apply 18th century English jury practice to 21st century American litigation. So the Seventh Amendment, as I mentioned, is based on the distinction between law and equity. And in England, in the late 18th century, both common law courts and equity, or chancery, played a role in patent litigation. An action to invalidate or revoke a patent was in chancery only. And chancery could issue injunctions, which the common law courts could not. And chancery, of course, sat without juries. Generally, as Jim describes, if a patentee sued for damages rather than an injunction, the action was at common law court, and factual issues were tried to a jury. Now, the factual issues might include issues that touched on the validity of a patent, but the decision of the jury bound only the immediate parties, not others. To further complicate matters, chancery, the chancellor, might, in his discretion, get help from a common law jury in deciding factual questions. So as we can see, there are major differences between patent litigation in England back in the 18th century and in the United States in the 21st. One of the most significant, of course, is the merger of law and equity with the Federal Rules of Civil Procedure in 1938. After the merger, of course, only one action needs to be brought for both damages and an injunction. Furthermore, as Mark Lemley has observed in an article in 2013, patents in late 18th century England were generally much narrower than today. Each patent covered a specific machine, described in detail, rather than a limitless group of machines that fit the words of a claim. Patents in the 18th century did not have actual claims, as Jim points out. Rather, there were specifications, which could be viewed as analogous. But there were many issues that juries would not have decided, or at least in nothing like their modern form: obviousness, patentable subject matter, statutory bars. But some of the most important changes were procedural rather than substantive. So in England in the early 18th century, a judge often asked a jury to give a verdict on specific issues of fact, without a general verdict or even a specific verdict on an ultimate legal question. Now, this was within the judge's discretion. In some cases, the judge would give broader questions to the jury, but he need not. English judges could and often did isolate narrow questions of fact for the jury, while the judge ruled on the ultimate legal question. Not only that, but English judges could heavily influence juries in their determinations of specific facts because of their strong powers to comment on the evidence. One commentator described English judges at this time as leading juries by the nose in deciding cases. Juries usually accepted the judge's leadership in these matters. And this is, of course, very far from the practice of trial judges today, and it makes jury trial a quite different thing from what it was in the late 18th century. Another hugely significant difference is in practices of jury selection. Now, Jim has told us about the special jury in England and how, in a complicated case, judges would routinely refer these matters to expert jurors. Besides that, even members of ordinary juries had to meet property qualifications, and, significantly, voir dire did not exist. It still does not exist in England. Lawyers cannot pose questions themselves or through a judge to get information to discover whether a juror is likely to be favorable or unfavorable to the case. Several American trial lawyers have told me that the case is won or lost in jury selection. A good friend of mine tries patent infringement cases, usually representing the plaintiff. She tells me that she tries to strike from the jury everyone she thinks is intelligent or educated. I've read that other lawyers representing plaintiffs in patent infringement cases try to do the same thing. The reason, she and others say, is that it can be hard to understand the arguments the defendant is making about the possible invalidity of the patent or the scope of its claims. Now, not only do our current jury selection practices raise important questions about the competence of the jury, to decide these matters, but it also undermines the often repeated argument that the jury is democratic and represents the community. The jury is not representative of the community if the lawyers can pick them over carefully for partisan advantage, as they do. It may be better, in patent cases at least, to abandon the pretense of the jury being representative of the community and to focus on competence instead. Now, Jim and I both agree that a special jury in a patent case would satisfy the requirements of the Seventh Amendment, although, of course, that is not the practice today, and in large part because of the federal statute. But statutes can be amended. A technically qualified jury could be very useful to judges in deciding patent cases. Federal judges often worry that they do not have the technical expertise to decide these cases themselves. And this is one of the reasons why they praise juries. The Markman decision that Jim talked about, holding that construction of patent claims is a question for the judge, not the jury, has caused great problems for judges. They struggle with lengthy Markman hearings and technical definitions and state of the art. Special juries could be a useful aid to judges in this and other matters. There is another alternative consistent with the Seventh Amendment to adjudication by juries or judges, and that is administrative law judges. So a hugely important recent development in patent litigation, of course, is the creation of the Patent Trial and Appeal Board, or PTAB. And we'll hear more about that this afternoon. The PTAB, at least in its design, is an excellent system of adjudication. It's so good, in fact, that it seems wondrous that such a scheme would have been enacted by Congress and signed by the President. So you'll forgive my being a little jaded about politics. And an interesting question is how that provision got enacted. I'm curious about the interests that lay behind that part of the America Invents Act, and if anyone knows about the history of it, I hope that you'll share it with us today. Clearly, one of the concerns was that the PTO was approving too many patents, but I'm sure there's more to the story, and I'm interested to hear it. The PTAB embodies many of the best practices of adjudication, those that are followed by other countries in civil cases. For example, technically competent judges. PTAB judges, as I'm sure you know, must have a law degree. They must be technically competent, meaning in practice that they have a bachelor's degree or higher in a scientific or engineering field. Many have been former patent examiners, and all have at least 10 years experience, and many considerably more in patent work. One of my favorite comments about the PTAB was this one by a lawyer who practices in front of them. The PTAB judges are well versed in technology and are intimately familiar with the patent laws. Arguments and styles that may resonate with a district court judge or jury risk falling flat at the PTAB. In other words, lawyers can't bamboozle PTAB judges the way they might be able to ordinary juries or judges. Not only are patent judges competent, but they sit in panels of 3, which helps judges to check each other and to prevent the bias of one judge from dominating the proceedings. Furthermore, PTAB judges must issue written decisions with reasons explained. This is another important check against bias or incompetence. Best of all, of course, from the litigant's point of view, they must issue decisions within 1 year, according to the statute, and the wonders never cease, they actually do so. To the extent there are delays in this litigation, they tend to be caused by review in the federal circuit. Now, I'm a believer in thorough appellate review. It's very helpful to correct error, but as one lawyer puts it, it helps to keep it snappy. So it's no wonder, given all these things, that the PTAB has been very popular with litigants. Well, this is all well and good, but is it constitutional? There are estoppel provisions limiting relitigation of these issues before Article III courts, including juries. In the past, schemes of administrative adjudication using administrative judges have naturally faced challenges under the Seventh Amendment. In his opinion in Atlas Roofing in 1977, the U.S. Supreme Court upheld a scheme of administrative adjudication under the Occupational Safety and Health Act. And in doing so, the court declared that Congress could set up administrative adjudication so long as the case concerned a so-called public right. But unfortunately, in Atlas Roofing, the court gave a very unsatisfying definition of public right that was essentially circular. The court took another crack at the definition in 1989 in the case of Grand Financiera versus Nordberg. And in that case, the court considered whether a right, even in a suit between 2 private parties, is, quote, closely integrated into a public regulatory scheme. Now, it seems fair to say that issues concerning the validity of a patent are indeed closely integrated into a public regulatory scheme, which Congress has the power to enact. And the Supreme Court has repeatedly described patents as an area of, quote, important public interest. And indeed, I would say, there is an excellent argument that all of patent litigation should be committed to a scheme like the PTAB. The court has held that Congress may create schemes of administrative adjudication for claims like those that were formerly handled by the courts. So administrative adjudication, it seems to me, is by far the most sensible solution to this muddle of the Seventh Amendment and jury trials in patent cases.
Thank you very much. Let me, so this has been a terrific overview and your two takes on the jury trial right. Very illuminating. So you've covered, Markman and how you think it's wrong on the history, the complexity exception, and how that maps onto various aspects of English legal history. There's also been, at least implicitly or explicitly, some criticisms of the historical rule in what you've said. And I very much also like, Renee, how you brought out the different aspects of patent litigation and how might we think to map them on, given that patent law and litigation look very different at the time as well. There's one other piece that I would love to just get on the table before we can open this up for questions. And Jim, you mentioned to me in the past that there's some evidence on when the founders were enacting, or the first Congress was enacting the first patent statute, that they considered the jury trial right.
Yes, it's quite interesting. It was unknown to me until recently, and I'll say a word about that. But preliminarily, let me just say one thing. Interestingly, Jeanne clerked for Justice Souter, so she's been interested to learn about this correspondence, but she said he often saved up his letters and responded to people during the summertime. Is that right?
Yeah.
Two quick things, and then I'll talk about the Patent Act. One other thing that happened in the late 18th century that is relevant theoretically today is I spoke about Judge Kenyon and how he was befuddled by maritime matters, and what he would do is not only rely upon special jurors, but the other alternative was to invite an assessor to come who was an expert on maritime navigation, usually a retired sea captain, and he would sit on the bench with the judge and whisper in his ear, explain what was going on when the witnesses were testifying, not as a witness himself, but as simply a helper to the judge. And this happened frequently, and that is still possible in federal courts, provided, and it's a big proviso, that somebody will pay for it. So I simply mentioned that in passing. The other comment I won't go into, but I'll just mention it. If there's time later, we can deal with it. The special jury exists only in Delaware, but the history of the special jury has a remnant in a number of other states because there was a special procedural method for comprising the special jury, and so it was alternately called a struck jury. And the way it happened, the officer in the court would call a specially large panel, not a panel of 24, but a panel of 48 jurors. And that panel of 48 jurors would then be presented to counsel for both sides, and counsel would take turns striking names off of the list until there were 24 left. And then those 24 would get the summons to come to the jury, hoping that 12 of them would turn up. So that is still in place in about a dozen states, the struck jury method. And you can think about the strategic implications of that, because if you have a list of all the potential jurors, you can scan the whole list and make some judgments about it in a very different way than juror by juror in the jury box method, where everybody comes and then you excuse some and bring up another one. Okay. Some of you may be familiar with the very helpful historical pieces that were published in the 1990s by Edward Walter Scheid, who was an amateur legal historian, but a very good legal historian, and he wrote a number of articles on aspects of the history of the patent process. And one of his articles was on the question of priority of invention, how the United States came to be a first to invent patent system. And this walks through the legislative history of the Patent Act of 1790 and the Patent Act of 1793, both of which this was going on at the time the Seventh Amendment was being formed. And one of the debates in the original House bill and the Senate bills that were proposed toward what became the Patent Act of 1790 was a debate in this priority issue. The debate was whether there would be a jury trial or not. There was a jury that was in the House bill. In the Senate bill, instead of a jury, there was a formula of submitting any issue that needed to be resolved to 3 referees, 2 of whom would be alternately chosen by the parties, and then the third would be appointed by the government. Ultimately, the jury part of that bill was dropped, the Senate version was adopted, and that statute became law. And then there was a rethinking of this statute in 1793 when this issue about jury trial came up again. And in that case, again, the jury was discussed and ultimately not adopted, and the 3-person decisional panel was continued, although this time the 3 members were called arbitrators instead of referees. And so it's an interesting, and it was new to me, this sort of background activity that was taking place while the Seventh Amendment was being formulated. Sorry, one more point. In Markman, after Justice Souter worked through the fact that he didn't think that there was anything like the claim in the known law from 1791, he said, and besides, it was clear in English law at the time that questions of interpreting words in written documents went to the judges, not to the juries. And he cited one case, the Macbeth case, for his authority, saying that here's an example. And that was a 4-judge Court of King's Bench case. And I explained in my jury book why I think that was a little misleading, because if you read that decision, you discover that the 4 judges, only 2 of the 4 judges were clear that unequivocally these questions went to a judge and not a jury. The other 2 said, wait a minute, if there's some real factual issue with regard to these terms in the written instrument, that has to go to the jury. And in Markman, there was a contest about what the word inventory in this dry cleaning methodology meant. And there were conflicting understandings of the word inventory. So even under this case cited by Justice Souter, I think that question would have gone to a jury as well.
Thank you very much. We have some time for a few questions.
I'm what's been referred to here as an ordinary judge, and therefore necessarily I'm an amateur legal historian, probably not a good one. This is fascinating. I want in just a minute to give you one trial judge's conception of the Seventh Amendment, the mandate. I'll sit down. My question is simply this: what's wrong with what I now explain? I think of it like this. 1791, we have an array of cases in our courts. Think of it like a pie. There's 2 slices out of the pie. One, no one's mentioned, not relevant to this conference, admiralty cases. Admiralty cases traditionally didn't have juries. Equity cases didn't have juries. Everything else had juries. That's how it was. Now that's then, and you've given us the history, all of which I agree with. It's history. Today, we've got this huge, big expanse in the type of cases that come before our courts. But it seems to me doctrinally, the pie slices still work. Those that are wholly admiralty, I know there's the savings to suitors clause, but wholly admiralty, no jury. Wholly equity, Beacon Theaters and the like, wholly equity, no jury. Everything else, jury, my view. Except, and Professor Land has pointed out, there's a bite out of it after the Roosevelt era. I express no judgmental view. And we have now all these administrative agencies which take care of the public rights exception that the Supreme Court has held. You don't get a jury. And if we're going to, Congress can pass these agencies which can regulate behavior, then that their regulation, they can enforce their regulations. The limitation that the Supreme Court seems to have drawn is the remedies that they can impose. That is, again, the PTAB. And I agree with where you've drawn the line. What the government giveth, the government patent monopoly, the government can take away. You don't get a jury. Infringement is something entirely different. Infringement carries with it the potential of damages. When you start moving money, that historically, as I understand it, has been a matter for the law courts. My question, what's the matter with that?
Go ahead.
This afternoon, Mark Limley will be speaking, I think, to some of what you're talking about, especially the latter part of your question. But basically, I don't have much disagreement with what you're saying. It seems to me that the administrative question is, of course, I concluded a long piece I wrote about the Seventh Amendment with a heading that said apples and oranges, because we're using the 1791 test still because the Supreme Court says we must. But the situation that we face in today's world is just different in many fundamental ways, and the administrative apparatus that is so extensive now, it was simply unknown in the 18th century. And so I take your point, but what the Supreme Court is going to do about it, if anything, just finally, the unanimity that was present in Markman is long gone on the Supreme Court with regard to the scope of the Seventh Amendment. And you can tell that by looking at the subsequent cases. The City of Monterey case, which is an eminent domain case, an indirect eminent domain case, 5-4. Yes, there was a jury required there, versus the Cooper case, where it was a punitive damage question, and Justice Thomas in the 5-justice majority said, well, punitive damages are not really the same as 1791 damages, and so that's not really covered by the Seventh Amendment. So that's a court question. So that unanimity, so who knows what the Supreme Court would do if it had another opportunity to take up the historical test. But the big question there that Renee and I have talked about and we haven't quite articulated now is the compared to what question. What would be better?
Yeah, that's the problem. So your characterization of the public rights doctrine as arising essentially out of the New Deal and the large administrative state that was created then, yes, certainly it vastly expanded, no question about that. And of course, even before that, the progressive era, they were doing plenty, as you know. But even before the late 19th century, there was long-standing public rights doctrine. It was narrower because the administrative apparatus was not as big, but it definitely covered, for example, tax cases. So there's a case where money was being moved around, but in England and America, essentially, court said, you know, don't need a jury.
That's a sovereign.
Right.
The sovereign tax.
Right, but the problem is, you know, where do you draw the line between rights of the state? It also might be a right of the sovereign to give somebody a monopoly in a patent. So that's the problem, is where do you draw that line? So it started out with questions like taxation, where the government governments not being stupid realized early that juries were a bad idea, right? So, and so it expanded with the idea of sovereign power.
Well, hearing Judge Young described as an ordinary judge, even by himself, is a historic moment for me, at least. So I have a reaction to Markman coming from outside. I'm not a patent lawyer. but I'm interested in its implications for the general Seventh Amendment principles. To the extent that the historic record is uncertain or contestable, it seems to reinforce Justice Souter's methodology, if not his conclusion. It seems to invite courts dealing with such a problem in the 20th or 21st century to say, okay, we're going to have a functional account of how this works. If you take the criticisms that have been put forward on this panel and couple them with Judge O'Malley's concerns about the actual application of Markman, perhaps we're deep enough into the history of this period to take up Justice Souter's methodology and say, as a functional matter, has this worked? And to say, okay, we have to draw a line between judge and jury, between law and equity, between courts and the jury as trier of fact. Has this particular line worked? That is, that the claim construction we hold in one domain and the damages in the rest of the trial in the other, or has it led to a bizarre system in which you have questions of law which are highly prone to being overturned by the Federal Circuit, and which force litigants, in order to preserve that issue for appeal, this is Steve Sussman's question, to have to go through a trial that they might otherwise not have to go through if there were one unified decision maker, be it judge or jury. And so perhaps this middle ground that Justice Souter crafted out of this functional test by its own terms has not worked. So I throw that out as maybe the conclusion of the first two sets of comments here, first two panels.
Yeah, I think Markman in practice, of course, has been very difficult. Difficult for judges to hold those hearings, and the law has grown highly technical and very difficult to administer. And then, as you say, because there's no interlocutory appeal, that's forcing parties to go to trial who might not otherwise have done so. So in practice, it's turned out to be very difficult, very problematic, and added to the already considerable expense and delay of patent litigation. So yes, I would be in favor of handing the whole thing, well, of course I'm in favor of handing the whole thing to PTAB or something like it, but including for those reasons, because to bifurcate in the way that Markman requires and other decisions require is quite difficult to administer for the litigation system.
I would just say, Sam, two things. One, you people, you practitioners, we would be interested to know what you have to say in response to his question, because we have the impression, the loose impression, that Justice Souter's hope for efficiency in creating this, what came to be known as the Markman hearing, would be a great benefit to the process, but we have the impression that it really hasn't turned out that way, so it would be interesting to hear. Last thing I will mention, Sam, there may be no easy answer to this, but I brought with me a copy of this article from the Wall Street Journal from August 23rd of this year, and the headline is, "Patent Judges Should Be Scientists Too." So we're talking about the juries, but here's an argument that we need specialist judges as well.
Okay,
We
we have time for
a question here, and then we'll end with Judge O'Malley.
I'm wondering about the consequences of the Supreme Court's conclusion that Justice Story was a little bit too willful. His conservative nature got the best of him when he framed the historical test, as you know, Professor Wolfram suggested. And that insofar as you can discern an intent from the Seventh Amendment, is that the practice in the states where the federal courts sat should have dominated the question about whether or not a jury would be available in a given case. So I'm wondering if that makes any difference. If the court were to have followed the practice with regard to patent juries in the colonies and in the states up until 1812, would we have had a different regime? Would it have been more democratic? Would more patent cases and more of patent cases gone to juries? Do we know anything about that?
The several federal acts required the federal district judges, federal trial courts, to adopt the practices and procedures of the states in which they sat. The difficulty was, of course, that the Seventh Amendment is a federal right. And so it would have seemed strange for a federal right to vary state by state. And in the end, in the late 19th century, the Supreme Court ended up being very pro-federal courts developing their own procedures as opposed to following those of the states. So it was a very difficult question, and you know, as you obviously know, the federal courts did, in many respects, follow the practices of the states in which they sat. But the Seventh Amendment, being an explicit right in the Bill of Rights, creates a difficulty. You know, how far can you allow this to vary state by state? All the state courts, the state practices are different, and it would seem anomalous for something in the Bill of Rights to vary so much state by state.
Just quickly, I would love to have been a fly on the wall when the Markman case was being debated by the Supreme Court members. It surprised me that it was a unanimous opinion by Justice Souter, and it occurred to me in reflecting on it that it's at least possible, and I think I won't go there, but it's at least possible that Souter figured out that there is a lot of wiggle room in the historical test. And it might be a good idea to see if we can do a creative thing here and send claims construction to the judges, to the courts, and here's how we do it. And in other words, that it was a strategic decision, not really being true to the history here, but I think he was too honest a man to have done that.
There's a lot that I can debate you on, but I've just got two quick points. One is the comment about you shouldn't bifurcate. I mean, you started off your comments with how we should look at what the other countries do and how well they do it, and most of them bifurcate infringement and validity.
Oh, sorry, I meant by bifurcate, sorry. I should not have used that term, because I understand in patent cases it tends to mean separating the issues of, for instance, validity from infringement and damages and so forth. And I'm sorry I used that term. I shouldn't have. What I should have said was divide cases between issues that are for judges to decide and for juries to decide. In other words, divide the decision maker.
All right. The other point I want to make is this notion about that judges should be scientists, or that the PTAB judges are better qualified to decide cases. The problem is that, for one thing, every case presents a different kind of science. So you'd have to have somebody who was highly trained in every form of science in order for them to be an appropriate decision maker under that standard. Secondly, and I'll give an anecdote here, but I was on the committee that rewrote the Manual on Scientific Evidence. There were 4 judges and 6 scientists, and we got to the point of court-appointed scientists, court-appointed experts, and whether we should endorse the notion of using court-appointed experts on a regular basis. The scientists started laughing, and they said the notion that you would ever find a neutral scientist is ridiculous. Every scientist, once you get sufficiently trained to be, quote, a scientifically qualified person, you've got biases. And so that the result is, their view was that you're better off, and this is coming from the scientists, for purposes of informed decision-making, having someone that's not afraid of science, but that has not formed too many scientific biases, listen to those highly trained and make an assessment of who was most credible. So, I mean, I just don't think there is such a thing as a wholly neutral scientist.
Closing remark, Judge O'Malley. I'm in complete agreement with you as a believer in trial by jury, and I just would mention in Delaware, even though the special jury is available, the courts have almost stopped using it. And in talking about when they get a motion for a special jury, they would say, but wait a minute, we have been very successful in being able to communicate with ordinary juries just by taking care in our instructions. And so I think common juries, as they were called, frequently are up to the job.
Well, please join me. Oh, sorry.
Just a quick comments on this. So the PTAB judges, of course, face this issue of they're trained in a particular discipline, although many of them, of course, have worked in the patent system for so long that they've become more generalist. But the PTAB judges emphasize that they have to be scientific generalists, that even though they may have their degree in, for example, electrical engineering, they have to be familiar with chemistry and all sorts of other things. So they understand that, and they explicitly look for people who could be flexible. So that's one way they deal with it. And another thing is, of course, that there are 3 of them, so that they can inform each other and talk to each other, which is an extremely important feature. And I would love to see more use of 3-judge panels in all types of litigation. I think it helps to check bias and helps them to form better judgments.
Thank you very much. Please join me in thanking Jim and Renee for an illuminating discussion.